Hello, everyone. Welcome back. And I hope you all are doing great. We had stopped our discussion on this particular case in the previous class after discussing a few set of questions from the previous judgment of PV Narasimha Rao. And I also told you that I will be referring that particular case as the previous judgment because that has been overruled now by the Supreme Court, Honorable Supreme Court in Sita Soren versus Union of India. Okay. So in today's class, we are going to understand firstly that what were the other set of questions that were there in Narasimha Rao and how the judiciary have not touched on those and said that we agree with whatever was held in the previous case. So that set of question is about that whether these member of legislative body will be considered as public servant or not. Now, ma'am, why did this question come before the court? So, if you remember, we had discussed that there are certain provisions that we'll be covering. Okay, I did take you to bribery, the offense of bribery under IPC. I told you about criminal conspiracy that is so there. Now we go to prevention of corruption. There is a particular offense that is so given under section 13 of the Prevention of Corruption Act, which talks about criminal misconduct by a public servant. So for us to say that this particular person, Sita Soren, has committed the offense of criminal misconduct under Prevention of Corruption Act, we will firstly have to tell that this person who's the member of the state legislative body is a public servant, first thing. Secondly, what is the procedure to prosecute a public servant under this law? And thirdly, how do we really say whether she has committed criminal misconduct or not? So this judgment basically revolves around the idea of immunity that is to be given. It does not talk about whether she has actually committed the criminal offense or not. So the question here is that whether she is a public servant, whether the prosecution can be done against her or not. The court here answers in Sita Soren versus Union of India and tells that we do not doubt the previous judgment in context of whether the members can be considered as public servant. Now, I'll tell you that how the previous judgment then decided and deciphered that they will fall under this category. So I'll take you to the Prevention of Corruption Act, which is so here. Okay, this is Prevention of Corruption Act, and then we have Section 2C. Section 2C, which gives us the definition of public servant, and it uses the term means, which tells us if you've understood the rules related to interpretation, you will get an idea that this is from where we can depict and understand that this is an exhaustive definition, right? So public servant means who? We come to the 8th clause. Any person who holds an office by virtue of which he is authorized or required to perform any public duty. So the person who is holding an office and is supposed and is expected and required to perform any public duty, the court said in the previous judgment that they will be considered as a public servant, and so are these members of the legislative wing. Then the next question that was so there raised before the court was with respect to how do we really prosecute them? Okay, so I have taken you to now section 19 of the Prevention of Corruption Act, which says previous sanction necessary for prosecution. Okay, so you require a previous sanction from a category or authorities that are so mentioned in section 19 if you want to prosecute any of these people or any of the public servants. So the question before the court was that whose previous sanction would be required when we are talking about these legislative, the members from the legislative body, which was answered in the previous case rightly as that it will be the Speaker of the House. So that is how the court has now very clearly understood that they are public servants. Secondly, we have a mechanism also wherein the previous sanction, if required, will be taken from the required and requisite authority. But let me just tell you that this judgment of PV Narasimha Rao also stated that we will not need this previous sanction because these public servants are given immunity by way of Article 105. So that sort of a blanket immunity that was so granted, or at least it was appearing to, that it is a blanket immunity that was granted to these members, and which is now, no more there, which does not continue anymore there. So we refer to the Prevention of Corruption Act to understand, firstly, the definition of public servant. Secondly, to understand that how do we really go ahead with the idea of previous sanction. You will also study and you will also find this procedure of previous sanction in criminal law, in CRPC, now BNSS also. And likewise in this special law also, it is so accordingly mentioned that if, this is a case of a person employed in the central government, it will be by the central government or the state government that you have to take the previous sanction before you prosecute them. Okay, now this is about Prevention of Corruption Act, and this is about the next leg of question which were so discussed and which were so covered by the judiciary in the previous case. And now if I take you to the copy of the judgment, okay, let me just show you the copy of the judgment as well, so that you see here that the court has very clearly answered that we do not go into the second question. Okay, so I am highlighting the second question, whether an MP falls within the purview of Prevention of Corruption Act and who is designated as the sanctioning authority. The court says that we will only be dealing with the first question, that is here, and not the second question. So they have not got, they did not really get into the discussion of the second question because they don't challenge it, and they only talk about the first question, that is whether by virtue of Article 105 of Constitution an MP can claim immunity from the prosecution of on a charge of bribery in a criminal court. So this is the discussion with which I started the first class on this particular topic. So if you have not you have not covered the first lecture, please go back and see the first lecture on the topic, because that is from where we start our discussion and we try to understand as to what is really happening, what has happened in this previous case of PV Narasimha Rao, okay, and what is happening in the recent case of Sita Soren versus Union of India. Okay, so we have covered the first judgment, which is now overruled. Okay, and we have also covered that what was held there. They made a distinction between bribe givers and bribe takers. They made a distinction between a person who is voted and not really voted. And now we come to Sita Soren and we try to understand that what is happening here. What did she really do? What are the facts of this case? Now, why are the facts of this case really important for us? When I was in college and we had sociology that we had to study, there was a famous saying which I studied, but I did not really relate to it till I became a lawyer, till I started practicing. And that is that lawyers are social engineers. Now, why are we called social engineers? Because we have to understand society, we have to understand the fragment of society, correct? Likewise, you have to understand facts of a case for you to decide what should be right and what should be wrong in a given situation. So what did happen in Sita Soren versus Union of India is that Sita Soren took the bribe for voting for a particular person. Okay, and I'll not be naming the name of the parties, but in Jharkhand, when the Legislative Assembly was going through this procedure, what has happened here, the catch here is that she has taken the bribe, and we have to read it in context of Narasimha Rao, okay? And she voted also, but she did not vote for the person for whom she's taken the bribe. Rather, she votes her own candidate. That is the catch. That she goes ahead and she votes for her own candidate. And now when she is prosecuted, she immediately reaches to the court and says that, no, I know and I am aware about PV Narasimha Rao judgment, and I feel that I cannot be prosecuted because I have exercised my right to vote, and Article 105 provides me and gives me immunity. So do we really have to get bothered about who did she vote for? Do we really have to show that whether, her vote will give her or grant her immunity or not, is the discussion that we have to do and understand. So I hope you're clear with the facts. The facts are so mentioned over here as well. Okay, it was all these are facts, and there we say that the petitioner was charged with bribery and criminal conspiracy under all these provisions that I had told you earlier. And she was accused of receiving bribe also, but she said that I have instead voted for another candidate, and therefore I have not committed bribe at all. So now I will take you to the copy of the judgment. We go to the original copy of the judgment and we try to see what is happening here. So here the Supreme Court's jurisdiction has been invoked. If you see that it is in the Supreme Court of India, criminal appellate jurisdiction. So you have reached to the Supreme Court by invoking the appellate jurisdiction, criminal appellate jurisdiction of the Supreme Court, and that is Sita Soren versus Union of India. I tell this to my students, each student, that when you get a judgment, and in that judgment, if you get table of contents, it is a brownie point for you when you're reading, because you know what all is covered here. So let me just take you through the table of content. It talks about the overview of the previous judgment as the way we started and we understood the previous judgment. Then it talks about the submissions and reconsidering, that if we go back and if we reconsider the previous judgment, will it be violative of stare decisis? So there was a long discussion as to this previous judgment being decided by the constitutional bench, and now can the constitutional bench again challenge the previous judgment, overturn the previous judgment? Do we have to refer it to a larger bench? These are the discussions which happened before the court, and that is why the court has answered it by saying that if we reconsider the previous judgment, which is a 5 judges bench judgment, and the reconsideration and the overturning has happened by 7 judges bench, it will not be violative of the principle of stare decisis. Those who do not understand stare decisis, we relate it with Article 141 of Indian Constitution, which says that the judgments have to be binding. Whatever the Honorable Supreme Court decides, it will be binding on that court as well as all the courts that are subordinate to it. If it is binding, how do we challenge? Who do we challenge it to? And if at all there are any changes that we make, will it not be violative of the rights? That is why, will it not be violative of the idea of constitution? That is why this was challenged, and this is called as stare decisis. Stare decisis means that you let the judgment stand and you respect the judgment, you honor the judgment, and that is why it is binding. But this does not mean that this rule of stare decisis is inflexible. Okay, it is a flexible rule, and we will discuss how. So that is our discussion that has been done in the judgment. Then we also talk about history of parliament privileges in India. Now let me tell you, why is this history important? Every judgment that you will read, all these landmark judgments, most of them basically talk about the history of the concept on which the judgment is based. Now, why is the history important? Because to understand the reading of the term anything in 105, I must know that what was the intention of the legislature. Let me take you to 105 once again. This is Article 105, and I'll just tell you which is the term, which is the most tricky term here. The most tricky term here is anything. Anything said or any vote given in respect of. Now this becomes, this is where the scope of interpretation comes, that what can be included in this anything. Does it also include offenses? Does it only include certain set of things? And that is why the court has to get into understanding the history of this particular concept, the history of the immunity that are so granted, and then accordingly decide and say that, okay, how do we want to interpret it in the present situation? So that is why history becomes very relevant for us whenever you as a judge have to decide something. Okay. And then we also see the purport of parliamentary privileges. Now, this is where we are, getting into the paradox that we are seeing, that what is the functional analysis? What was really the function and how is it really working? We see that, this parliamentary privilege is a collective right. We have to see what are the different type of tests that have been given. So this chapter, this particular part, we are going to understand that how is this particular privilege and immunity being used in a concocted manner or in a twisted manner. Okay. And then very clearly the judges have answered. You can see it from the title or from the table of content itself, that bribery is not protected by parliamentary privileges. So if you get a MCQ from this table of content itself, you understand that bribery is not covered, bribery is not something which will be allowed, and it does not have any nexus with anything done or anything said. It envisions probity in public life. Okay, so if when you talk about constitution, the idea is to promote more and more respect in the public life, right? And this idea of bribery is absolutely against it, and it defeats the probity. The courts and house exercise parallel jurisdiction over allegation of bribery. So there's a discussion done with respect to who decides. Then if you do not allow the judges, if you do not allow the courts to take a legal action, then which is that authority that is going to decide? Does the parliament has this power? That is why it says court and the house exercise parallel jurisdiction. So you can't say that the courts cannot take cognizance and cannot prosecute if only and only because the house has started a disciplinary proceeding against these members. So this becomes also very important. And then when do we really say bribery is complete? This is a very important question, wherein we will see it being addressed also, wherein the court has said that bribery does not really require or does not really mean that you have to vote or you have to exercise or act in furtherance of the bribery. The act of bribery is taking the money, deliver or accepting the money, or to give the money away, and that is very clear from the definition of bribery. So these are discussions that have been done in the judgment, and then we have comparison to the international provision as well. Okay, so as I told you, this judgment, I'll just get into the question and the concept of stare decisis right now itself. The concept of stare decisis, as I told you, says what? That we have to respect the judgment. Okay, the judgment has to be respected, it has to be binding, and it has to be followed accordingly by all the subordinate courts. Now the question is that who gets to challenge it? Then which court will we allow for it to be challenged? So in this case, PV Narasimha Rao judgment was decided by a bench of 5 judges, the constitutional bench. Herein it has been questioned. Okay, the questioning of the judgment was done by an equivalent bench, that is the 5 judges bench, and it was further referred to a bench of 7 judges. So the decision has come from a bench of 7 judges, and herein the court says that if we follow this, it is not against the principle of stare decisis. So let me just take you through the important paragraph from the judgment, wherein we have held so. The court respects and says that we believe Article 141 is there, and however, a bench of the same strength can question the correctness of the decision rendered by a coordinate bench. So it can be again questioned by the bench of same strength, first point. And in this situation, in Sita Soren, as I told you, it was referred to a larger bench, that is the 7 judges bench. Okay, then we are saying that it is, there are several previous decisions also wherein it was so suspected that the previous judgment of Narasimha Rao does not look good, but it was nowhere, questioned, it was nowhere overturned, or it was nowhere, considered to be violative. There were just doubts as to the correctness that was shown in the previous judgment. And, one of the judges in the present judgment is the then Honorable Chief Justice of India, who had shown concerns in other judgments also, but he very clearly mentioned that if at all it becomes necessary in an appropriate case in future, we will refer it to a larger bench to consider this issue again. So we have followed the hierarchy, we have followed the doctrine, and we do not violate the principle of stare decisis. So these are certain important parts wherein, the court has clarified and said that this is absolutely valid. The judgment is not invalid. Now I'll take you and I'll tell you which part to read. Okay, the part that I am removing right now, this fresh part. The court has said that we do not consider it appropriate that the court has to confine itself to such a rigid understanding of doctrine of stare decisis. The ability of the court to reconsider its decision is necessary for the organic development of the law. So for the organically developing the law, seeing that how the law has to change in advancement of justice, we will be overturning the previous judgment, and that is very well recognized in the constitutional jurisprudence as well. Okay, so we have covered the concept of stare decisis so far in the context of Sita Soren, that the court has clarified and told us that we are not violating the essence of constitution. These are the honorable judges who have decided this particular judgment. The 7 judges bench comprised of the following judges. You can expect, if you're preparing for judiciary or for any exam, you can expect a question asking about the strength of the bench as well as the who were the judges who took part in the judgment. Okay, so you must also know about the name of the judges. Now, I'll tell you how you can easily remember. Firstly, remembering the name of the case law is if you relate and if you know that Sita Soren was a member of the legislative body. So that way it will be very easy for you to know that, you must be knowing also that PV Narasimha Rao has been our honorable prime minister at one point of time. You must know and you must identify Sita Soren as being the member. And if you have to remember the name of the judges, just a quick tip that you can, when you go to LiveLaw, when you see any article or when you see the summary of the judgment, you see the name of the judges also. So when you're reading it, just see and faces, just see that how many judges are there in addition to the title, and you will have some pictorial memory of remembering the name of the judges as well. But that has to be done continuously. You have to revisit and again see those faces and remember those judgments. Or one more thing can be that you make a summary of it, right? So you say that, okay, I am talking about the Honorable Chief Justice of India, then Chief Justice of India, and then you accordingly write his name and write what all landmark judgments in which he has actually been part of the bench. And accordingly, you will remember. So there can be different ways of you remembering, but you have to actually remember these names for your judiciary preparation. Okay. All right. Then we go to these answers. Okay. We try to find these answers as to what all has been questioned and what all has been seen in this particular given case. So I'll tell you, let me just take you to the 3 questions, primary questions of Sita Soren versus Union of India. I'll briefly, in my own language, I will tell you what are the 3 questions considering the context of PV Narasimha Rao in mind. The court says that we will be finding the answer to these questions. The first one is that if there is any act or any offense, for example, bribery that you have taken or criminal conspiracy that you have done, if there is any such act which is independent from the act of a member as a member of parliament, can criminal proceedings be done against them or not? If you have done bribery, okay, and just because that bribery has a nexus with you exercising your right to vote, it has a nexus because I will be establishing I gave you bribe because of this reason. But is it part of you being the member of the parliament? Is it something that is necessary for you to function as the member of parliament? No. That is why it is independent from you acting as a member. And in that situation, do we allow you immunity or we do not allow you immunity is the question. So that is the first question that we are going to discuss. The second question is with respect to the division or the paradox that I told you about. No immunity would be attached and the member of the legislature would be liable to be prosecuted if they accept the bribe for not speaking, for not giving their vote, but they act to do the contrary. So if you do not really vote, you will be prosecuted. No immunity will be available to you. So this was a paradox we have to answer and address. Do we continue with this division or do we not continue with this division? Okay. And the third question is, when does the offense of bribery become complete? When do we say that yes, bribery has been completed? When you have accepted the money, when you have given the money, or when you have acted in furtherance of that particular money that is so given to you. Okay, so these are the 3 questions that the court has addressed in this particular judgment very clearly in their own words. Okay, I hope you are clear with these three questions, or when you're making your notes, you can pause and you can accordingly write in this manner. The one is about paradox of division between two class of people. The first one is, if something, an act is absolutely irrelated, not related to the act of you being the member, will that be considered or not? So an independent act, can you be granted immunity for that or not? And third is, when do we say that the offense of bribe is complete? These are the three questions that the court has tried to answer in this particular given case. Okay, now we move ahead and we try to find the answer to the first one. Okay, so we will go step by step. I have shown you these different offenses that are so there, that are so covered in this particular case. Let's try to find out that why do we allow you these privileges and what is the extent of this privilege. So the judiciary has very clearly mentioned in this judgment that we are different from other countries, even though, so how we had multiple laws. Okay, we had the law of 1861, which was very stringent. We had 1909, 1919 Act. We had different laws wherein there was a curve. Okay, I can say there was a curve of what will be the strength of parliamentary privileges given to you. So parliamentary privileges were introduced by Macaulay, and it continuously remained there. But the extension, or the the authority under immunity was, sometimes it was larger, sometimes it was much more narrower in nature. So that is why I'm making this curve and telling you that it varied from time to time. Okay, I'm giving you an example also. The Act of 1861, very clearly, it was very stringent in nature, and it tried to curtail the immunity that were granted. And the reason is very basic. We have evolved in a different manner as compared to the other common law countries. Okay, or when we specifically talk about England, there they had a conflict between the crown as well as the on the other side there was legislative body, and out of this conflict they decided that we are going to get these many parliamentary privileges. This has not been so in India. In India, rather, we codified and we gave these privileges to ourselves by virtue of the statute, and therefore we also allow a different ambit to it. Like Article 105, Clause 3 tells us that we can legislate and we can accordingly, from time to time, decide that what will be the ambit of our privileges or immunities that is to be so granted. Okay, so the history of parliamentary privileges is absolutely different in India as compared to UK, and the ambit of the power is also different. So that is why the court has decided, and the court has said that we refer to it in a different manner, and we see it as to be, that whether it has been whether the parliament has the absolute power to deal with it, whether the judiciary can interfere, in what situation can it interfere, when can the parliament legislate on the new immunities that are to be granted or curtail the immunities that so exist. So the history is absolutely different, and in the context of the history, the court concludes and says that we have to ensure the idea of constitution, democracy, and privileges go, and there is balance between all three of them. And that will happen when we allow judiciary to interfere, when we allow judiciary to assess, to relook, and to decide that whatever changes or whatever legislations are made by the parliament on this concept, the judiciary can do a review of the same. Okay, so that is why we are curtailing. By this, we are getting an idea that we can curtail, or we have to curtail these immunities and privileges, and we have to read it in them in the given context. So here I stop now today's class. We meet again tomorrow in the third leg of this discussion, where we conclude the judgment, wherein we understand that, how the judiciary has answered these questions. Okay, so tomorrow we meet again. If you like the lecture, please feel free to drop a comment. If you have any doubts, you can leave it in the comment box. I would also urge and request you that if you feel that I should be covering any judgment that, which you find difficult, which you feel is important, which we must cover in this series, you can definitely let us know, and I'll be more than happy to cover that in our coming lectures. So thank you all of you for your patient hearing. I hope this was beneficial. I hope you get benefited out of reading these case and judgments with me. Thank you, all of you.